So for the introduction part, I'll be talking about state responsibilities. State responsibility means that a country is legally responsible for actions that are wrong in the eyes of other countries. There are legal penalties for these actions because they break foreign agreements. The key elements of these are wrongful act, which means violation of an international obligation. Attribution, the act must be attributable to the state. Damage not required, responsibility can exist even without any actual damage. It must be codified in the International Law Commission's article on the responsibility of states for internationally wrongful acts, which is known as RCWA 2001, and must be recognized by the International Court of Justice and other international tribunals. It is typically invoked by an injured state, which is a state directly harmed by the wrongful act. Exceptionally, a non-injured state can invoke responsibility when obligations breached are owed erga omnes to the international community as a whole, example, prohibition of genocide, or when a multinational treaty meant to protect everyone's interests is broken. It affects everyone's responsibilities under that treaty, for example, environmental protection treaties.
Myanmar is known as a Buddhist majority country. Rohingya is only the Muslim minority. The Myanmar government has denied them citizenship and see them as the illegal immigrants from Bangladesh. The clearance operations follow decades of systematic persecutions of Rohingya by the government. Due to the long-standing operations in Rakhine State toward the Rohingya group, the Arakan Rohingya Salvation Army AUSA, an armed Rohingya insurgency, has grown with its main purpose is to protect the Rohingya Muslim minority from the state repressions. On 25 August 2017, AUSA attacked police posts in Rakhine State. In turn, this prompted a counter-insurgency clampdown from the security force. The government declared AUSA as a terrorist organization. The military mounted a brutal campaign that destroyed hundreds of Rohingya villages. At least 6,700 Rohingya was killed in the first month of the attack. Myanmar security force also allegedly opened fire on the fleeing civilians and planted landmines near border crossing used by the Rohingya to flee to the Bangladesh. UN fact-finding panel released a report that claimed that there was clear pattern of abuse by the military, including systematic targeting of the civilians, committing sexual violence, promoting discriminatory rhetoric against the minority, and creating climate of the impunity for the security force. In 11th November 2019, the Republic of Gambia filed a lawsuit at International Court of Justice, or we call ICJ, against the Republic of the Union of Myanmar for violating its obligations under genocide conventions. This historical lawsuit seeks to ensure Myanmar's responsibility as a state for the genocide committed against the Rohingya. Both of the Gambia and the Myanmar are the party who signed to these genocide conventions. The Gambia refused to stay silent in the face of the genocide and took an important step in filing a case against Myanmar at ICJ. As part of its filing, the Gambia requests the ICJ to issue provisional measures which, if granted, could impose immediately binding obligations on Myanmar. In its applications, the Gambia sought to base the court jurisdictions on Article 9 of the Genocide Conventions in conjunction with Article 36, Paragraph 1 of the Statute of the Court or the Statute of ICJ. The applications contain a request for the indications of provisional measures submitted pursuant to the Article 41 of the Statute of the Court and to Article 73, 74, and 75 of the Rule of Court. Gambia also described in its applications that the prohibitions of genocide has the character of preemptory norms, and the obligations under the conventions are aus ergas omnes in ergas omnes partes. The Gambia has in particular made clear to Myanmar that its actions constitute a clear violation of its obligations under the conventions. Despite all the evidence, Myanmar continued to deny any wrongdoing and has rejected any suggestions that it violated the genocide conventions. Myanmar argues that the crackdown was aimed at the Rohingya rebels who carried out attacks. Aung San Suu Kyi, as a state councillor, defended the military of the Myanmar when attending ICJ. She has denied that there is no ethnic cleansing for Rohingya Muslim minority in Myanmar. There was few objections raised by Myanmar. First, Myanmar previously argued that Gambia lacked standing because it filed its applications as a proxy for the Organizations for Islamic Cooperation, or IC, while the ICJ was established to preside over the dispute between the state, not with intergovernmental organizations. Second, Myanmar argued that there was no dispute between Gambia and Myanmar on the interpretations, applications, or the fulfillment of the Genocide Conventions as required by the Article 9 of the Convention. Third, Myanmar argued that its reservations to Article 8 of the Genocide Conventions. Article 8 of Genocide Conventions enables the state party to the conventions to call on competent UN organs to take the actions to prevent and suppress genocide, such as ICJ. So here, the reservations precludes Gambia from pursuing actions at ICJ toward the Myanmar. Finally, Myanmar argued that the Gambia was unaffected by the alleged breach of the Genocide Conventions and therefore lack of standing or the legal right to bring a claim. Myanmar suggested that the Gambia was not directly affected by the event concerning to the Rohingya in the Myanmar, therefore did not have any legitimate legal interest or the standing to bring the case forward.
The evolution of the court approach to the standing of non-injured states. This gradual change in the ICJ stance on the standing of non-damaged or indirectly harmed states reflect a broader evolution in international law concerning communal interests. Originating under a bilateralist framework, international law has historically underscored the reciprocity of rights and obligations between states. Nonetheless, the acknowledgement of responsibility erga omnes owed to the international community collectively and erga omnes partes owed to specific grouping of nations under treaties has already altered the affirmation paradigm. This video examines the International Court of Justice law concerning the standing of non-injured states, highlighting its initial hesitance and recent pivotal cases like Belgium against Senegal and the Gambia against Myanmar. It examines the ramification of this development and the necessary action that remains to be undertaken. The action of non-injured state standing. In its early years, the ICJ was cautious about granting standing to non-injured states. Its approach was evident in the 1966 South West Africa case, where Ethiopia and Liberia challenged South Africa apartheid policy in South West Africa. The court dismissed the claims, ruling that standing required a direct legal interest in the dispute. It rejected the concept of actual popular which allowed any states to defend collective or public interests, and held that standing must stem from specific right or interest of the claimant states. The South West Africa decision was widely criticized for its narrow view of standing and its failure to recognize the growing importance of collective interest in international law. Scholars and practitioners argue that the ruling overlooked the essence of the mandate system and the international community share responsibility. By reinforcing a bilateralist perspective, the judgment marginalized community consent and limited states' ability to uphold global norms through litigation. The Barcelona Traction case, acknowledgement of erga omnes obligation. The ICJ's ruling in the Barcelona Traction case 1970 was another pivotal moment, although it did not directly address the matter of standing. In a significant obiter dicta, the court differentiates specific obligation due to the world community collectively referred to as obligation erga omnes. The prohibition encompassed atrocities such as genocide and slavery, along with the value of self-determination and racial non-discrimination. The court stated that these requirements were so fundamental that their breach concerned all states, which could be regarded as having a legal interest in adherence. The Barcelona Traction decision did not directly grant standing to non-injured states. However, it established the conceptual foundation for further advancement. The acknowledgement of obligation erga omnes indicates that certain standards surpass bilateral connection, establishing a foundation for future instances in which states could intervene to safeguard collective interests. Progressive development from Belgium against Senegal to the Gambia against Myanmar. The 2012 International Court of Justice (ICJ) ruling in Belgium against Senegal marked a key development in recognizing the standing of non-injured states. Belgium sued Senegal under the Convention Against Torture, arguing Senegal had failed to prosecute or extradite Hissène Habré, former president of Chad, accused of torture. Senegal countered that Belgium was not directly harmed by its action. The court dismissed Senegal's argument, stating that the obligation under the CAT are erga omnes partes, owed to all states party to the convention. This means every state party has a legal interest in ensuring the convention enforcement, even without direct harm. This judgment overturned the restrictive precedent of the South West Africa case and broadened the recognition of collective interest in international law. In the Gambia against Myanmar 2020, the Gambia accused Myanmar of violating the Genocide Convention through atrocities against the Rohingya minority. The ICJ upheld the Gambia's standing, reaffirming that obligations under the Genocide Convention are erga omnes partes. The court emphasized that the collective responsibility of state parties to prevent and punish genocide, rejecting Myanmar's claim that only directly affected states like Bangladesh should bring such cases. This reinforced the principle that all state parties to such treaties can seek enforcement of shared obligation.
The main distinction between erga omnes and erga omnes partes is the obligation. In international law, the term erga omnes refers to the obligation that states owe to the international community as a whole. This obligation arises due to the universal and fundamental interest in preserving critical rights and preventing their violation. As a result, any state has the right to invoke responsibility against a violating state to hold it legally accountable and demand reparation. Erga omnes obligation apply in cases involving serious breaches of fundamental norms of the international law, such as those prohibiting piracy, genocide, and wars of aggression. The concept was recognized by the International Court of Justice in the Barcelona traction case, which emphasized the distinction between a state's obligation to the international community at large and its obligation towards another state in matters of diplomatic protection. The court noted that due to significance of the rights involved, all the states have legal interest in upholding this obligation. Erga omnes partes obligation refer to the duties under a multilateral treaty that a state party owes to all the state parties to the same treaty. This obligation arises from shared values and a collective interest in ensuring compliance, allowing all states parties to act in response to a breach. Unlike erga omnes obligation, erga omnes partes obligation are strictly treaty-based and represent a more limited scope compared to the broader category of erga omnes obligations. Moving on, we are going to look at the challenges faced when non-injured states invoke state responsibility. First of all, lack of explicit provision in treaties. Not all treaties clearly outline the rights of non-injured states to invoke responsibility. In the case of Gambia versus Myanmar, jurisdiction relied heavily on the Article 9 of the Genocide Convention, which explicitly allows disputes between parties regarding the interpretation, application, or fulfillment of the treaty to be submitted to the ICJ. Many other treaties lack such provision, making it challenging for non-injured states to establish standing. Moving on, limited access to evidence. Non-injured states often face difficulties gathering evidence to substantiate claims of the treaty violations. In the cases like genocide or human rights abuses, evidence is typically located within the territory of the accused state, which may refuse cooperation or deny access. Thirdly, sovereignty concerns. Invoking responsibility for violation like genocide or human rights abuses often involves scrutinizing a state's internal policies and action. Accused state may argue that such intervention violate the principle of non-inference in domestic affairs. Lastly, ambiguity in scope. Even when jurisdiction is established, questions often arise about whether a particular treaty violation falls within the scope of the obligation owed to all states parties erga omnes partes. For instance, states might dispute whether a breach constitutes a violation of collective obligation or bilateral commitments. In conclusion, the ICJ's evolving stance on the standing of non-injured states highlights the growing recognition of collective obligation in international law. From restrictive ruling like Southwest Africa to progressive decision in Belgium versus Senegal and the Gambia versus Myanmar, the court has increasingly supported states acting to defend shared values even when not directly harmed. However, challenges such as jurisdictional ambiguities, evidentiary difficulties, and sovereignty concerns persist. To address these issues, clearer treaty provisions, stronger evidence gathering mechanisms, and balanced accountability are needed. The International Committee must continue to refine the legal framework for enforcing erga omnes and erga omnes partes obligation to ensure that fundamental rights are upheld and collective interests are protected.
The Articles on Responsibility of States for Internationally Wrongful Act (RCWA), finalized by the International Law Commission in 2001, codify the principle governing state responsibility in international law. This principle addresses situations where a state commits an internationally wrongful act, which must be attributable to the state and constitute a breach of its international obligation. RCWA outlined the legal consequences of such acts, including the duty to cease the wrongful conduct, provide reparation through restitution, compensation, or satisfaction, and take measures to ensure non-repetition. It also allows states to invoke responsibility under specific circumstances. Article 42 enables directly injured states to seek remedies, while Article 48 extends this right to states acting in the interest of a collective obligation, whereas obligation erga omnes or erga omnes partes.
Point discuss about application of the responsibility of states for international wrongful acts 2001 within the court jurisdictions. The primary purpose of RCWA 2001 is to guide states and courts in addressing issues of states' responsibilities. It codifies principles that are widely accepted in international legal practice and offers clarity and structure in determining legal obligation and breaches. Courts frequently use RCWA 2001 as a framework to evaluate cases involving state responsibility. By referencing its provision, courts can systematically assess whether a state's actions or omissions constitute internationally wrongful acts. Despite its non-binding nature, a critical aspect of applying the RCWA 2001 is the attribution of conduct to the state. For example, provisions include Article 2, which defines internationally wrongful acts, Article 4, which attributes acts of state organ to the states, and Article 8, which addresses conduct directed or controlled by the states. Courts also rely on these articles to determine whether specific actions can be legally attributed to the state, thereby by establishing the connections between state action and breaches of international obligations. Article 12 of RCWA 2001 defines a breach as the non-performance of an international obligation by a state. This article is often used by courts to evaluate whether a state's actions amount to a violation of obligation owed to another state. It helps in assessing compliance with international treaties or customary international law. Although RCWA 2001 is not a treaty, its provisions codify principles recognized as customary international law. This makes it harmonized legal framework that courts frequently reference even in the absence of explicit treaties. By doing so, RCWA enhances the legitimacy and consistency of judicial decisions in international disputes.
In the context of the Gambia and Myanmar case, RCWA plays a crucial role in framing state responsibility for genocide under the Genocide Convention. The Convention's obligations are erga omnes partes, meaning all state parties have a collective interest in ensuring compliance. Regardless of direct injury, this principle underpins the Gambia's standing to bring the case before the International Court of Justice, ICJ, as affirmed by RCWA, Article 48. Additionally, RCWA provides a framework for attributing acts of genocide to Myanmar and assessing breaches of its treaty obligation. If Myanmar is found responsible, RCWA principle will guide reparation, emphasizing adherence to international norms for wrongful act. The ICJ's reliance on RCWA illustrates its significance in addressing violence of fundamental international rules, such as the prohibition of genocide. Okay, so basically the application of RCWA in this context underscores its importance in addressing severe violence of international law, such as genocide, and in ensuring that states are held accountable for action that violate universally accepted norms and obligations. The reliance on RCWA in this case also highlight the central role of state responsibility in upholding international peace and security.
Classifications of accountability could be like vertical accountability, which allows citizens to hold their government accountable through elections. Horizontal accountability, which involves checks and balances between state institutions, ensuring no single branch oversteps its authority. Thirdly, diagonal accountability refers to oversight by civil society, organizations, and even media, acting as supervision to keep the government in check. A fair legal system upholds the rule of law, ensuring the justice is served impartially. To understand the possibilities of the court's decision on the Gambia v. Myanmar case, we have to look at the Genocide Convention, whereby first a clarification of state obligations is required, whereby the court's ruling could clarify the responsibilities of states under Article 1 and 5, whereby Article 1 obliges states to prevent and punish genocide, which is a decision against Myanmar, could underline the proactive duties states must undertake to fulfill said obligation. Secondly, Article 5 mandates states to enact legislation ensuring effective penalties for offenders. The court could emphasize on the importance of domestic legal framework in deterring such genocide from happening. Secondly, enforcement of individual accountability, whereby the ruling may strengthen the principles outlined in Articles 4 and 6. Article 4 affirms that individuals committing genocide, regardless of their official status, must be punished. Secondly, Article 6 specifies that those accused should be tried by competent national or international tribunals. The case could reinforce the necessity of holding individuals accountable, irrespective of their ranks or positions. Lastly, international cooperation, in which the case underscores the role of international mechanism under Articles 8 and 9, to which Article 8 enables states to call upon United Nations organs to prevent and suppress genocide, highlighting the value of collective international action. Lastly, Article 9 provides that disputes over the Convention's interpretation or application be submitted to the International Court of Justice, demonstrating the significance of legal avenues for resolving such heavy issues like the Gambia v. Myanmar case. Thank you. That is all.
Greetings and good day, madam. My name is PRIYADARSHNI. My matrix ID is 078008, and I will be explaining on the part limitation of court's decision for state accountability. So for the first point would be lack of universal jurisdictions. So courts often lack of universal jurisdiction over states, making enforcement of judgments difficult. The International Court of Justice, ICJ, for instance, requires state consent to exercise jurisdiction, limiting its ability to hold states accountable without explicit agreement. So example of case here is the case of United States versus Nicaragua, according to the ICJ report 1986 part 14, wherein the ICJ ruled against the US for supporting contra levels in Nicaragua. However, the US refused to participate in this case and later rejected the ICJ's jurisdiction, demonstrating the difficulty in enforcing judgments when state consent is absent. So the second limitation would be sovereign immunity. The principle of sovereign immunity often shields states from being held accountable in other jurisdictions. This can prevent effective remedies for wrongful acts committed by the states. So, example of case here from the ICJ report 2012, part 1899, which is Germany versus Italy on jurisdictional immunities of the state, wherein the ICJ held that Italy violated Germany's sovereign immunity by allowing claims against for Nazi-era atrocities. Sovereign immunity barred victims from seeking remedy even for the grave violations of international law. So the next point here would be the fragmentation of international law. The absence of cohesive legal framework leads to inconsistent application and interpretation of laws across different jurisdictions. This is exceptionally evident in cases involving state succession, where various theories such as continuity and fabula rasa conflict with another. The reference here would be from the ICJ report 2007, part 43, which is the dissolution of Yugoslavia, and the ICJ Bosnia genocide case 2007. Conflicting principles such as state succession and continuity complicated the accountability for crimes during the breakup of Yugoslavia, as Serbia was found not directly responsible for the genocide, but failed to prevent it. Fourth point here will be the dependence on political will. Enforcement of court decisions, including ICJ rulings, relies heavily on the political will of the states. International organizations like the United States. Non-compliance by states often remains unaddressed due to geopolitical consideration. An example here from the UN Security Council Resolution 1593 for the UN Security Council role on Darfur refers to the ICC 2005, despite ICC's indictment on Sudanese officials for the atrocities they have committed in Darfur, enforcement was hampered by a lack of political will among the major powers, it highlighting the incompliance with the court decision that we have discussed before. So the fifth point here would be the limited applicability of precedents. International courts generally do not follow strict precedents that are decisive. This means that even well-reasoned decision may not apply uniformly across similar cases, resulting in inconsistent accountability outcomes. Example of case here from the ICJ Advisory Opinion 2019, Part 107, the Chagos Archipelago case, Mauritius versus UK in 2019, the ICJ's advisory opinion on decolonization has limited the precedent value as it was not binding and the UK continued administration in the island despite its ruling. So the next point here would be the challenges in evidence collection. States often have the resources to obscure evidence, manipulate facts, and delay proceedings, which can hinder the effectiveness of the court decision-making process. So according to the ICJ report, 1992, Part 3, on the case of the Lockerbie case, Libya versus UK and USA in 1992, Libya's refusal to hand over suspects and evidence delayed the proceedings for years. States' ability to obscure evidences hindered the effectiveness, accountability, and mechanism. So the next point would be non-binding nature of the judgments.
Let's conclude the case of Gambia against Myanmar with the significance of the case. The case exemplifies how international law has evolved to recognize the standing of non-injured states, especially in cases involving obligation owed to the global community known as erga omnes. By allowing the Gambia to bring a case against the Myanmar, the ICJ reaffirmed the collective responsibility of states under the Genocide Convention. The provisional measures ordered by the court emphasize the importance of immediate binding obligation to prevent further atrocities, showing the ICJ's commitment to upholding fundamental international norms. This decision demonstrates that accountability for severe human rights violation is just not theoretical, but enforceable. Let's look into the impact of the court's decision. The decision clarified the state responsibilities, especially regarding the genocide prevention and punishment. It urges states to strengthen domestic frameworks to comply with international standards. Furthermore, the case highlights the role of international courts in protecting marginalized groups such as the Rohingya, ensuring their voices are heard to the global level. Let's look at the limitations and possibilities of the court's decision. On the positive side, the ruling reinforces the state's accountability, emphasizing the necessity for proactive measures to prevent genocide, encourage international cooperation, ensuring that severe violation of human rights norms are addressed collectively. The use of the RCW 2001 framework and the Genocide Convention set a powerful precedent for upholding states accountable for their actions. However, there are challenges and obligations. Enforcing the ICJ rulings can be difficult without mechanism to compel the compliance. Political resistance from states, as seen with Myanmar, often hinders the implementation of this decision. Finally, while a state accountability is emphasized, the individual accountability must also be pursued through domestic and international judicial procedures. And in summary, the Gambia against Myanmar highlights the critical role of the ICJ and the international legal frameworks in addressing atrocities like genocide.